Hi, Kathy with Atlanta Area Property Management. Today, this video is going to be a little bit longer than my normal ones. Well, as a property manager, a comprehensive tenant lease is essential to protecting your property, minimizing landlord-owner liability, and ensuring smooth landlord-tenant relationships. Well, making sure that you include the correct clauses in your lease can prevent misunderstandings and legal issues down the road. Well, these are my top 5 most important clauses that should be in your lease. Number 1, always have tenant rent amounts, fees, charges, and payment terms included in your lease. Now, I've never seen a lease without the rent amount included, but I have seen leases where the fees, such as late charges or tenant utility costs and other charges, were not included. Now, if you require the tenant to pay any additional fees for anything, your lease should include all of these amounts with very clear terms. What are terms? Well, terms are provisions in which your tenant must adhere to in regard to the payment of these monies, the due date, what kind of payments if they can split them up, what happens if they fail to meet the due date, are there late charges and how much, is there the possibility of eviction? Well, you need to clearly outline these terms and don't get into a fight with your tenant because he thought one thing and you thought another. And you certainly don't want to leave it up to the courts because you will surely lose and it will be expensive. It's essential to specify in your lease, number 1, the exact amount of rent and the fees. Number 2, the due date for these monies. And number 3, acceptable payment methods like cash, check, Zelle, or even online payment. And number 4, what happens if they don't pay on time? The important thing is to be very explicit about these details. My second important clause regards security deposits. By law, security deposits always belong to the tenant. Don't ever think that you can keep the monies just because you're a landlord. Security deposits are funds that can be applied to tenant-caused damage. In your lease, you should clearly outline the amount of the security deposit that you plan to hold. Okay? It should include the conditions under which you, the landlord, will retain some or all of the monies. You need to include the time frame that the deposit will be returned when the tenant moves out. And remember, this may be governed by your state's landlord-tenant laws, which will override anything that you put in your lease. Number 3, where will you be holding the security deposit? Generally, a bank account marked as an escrow is your best bet. Security deposit disputes are one of the most common tenant lawsuits, and if you do not follow the law in the state of Georgia, you could be liable for up to 3 times the security deposit, all the damages, attorney's fees, and anything else a judge may want to impose. So the important thing is for you to hold the security deposit separately and disperse it fairly. My third most important clause encircles maintenance and repairs. So maintenance and repair issues are the most common reasons why tenants move. Your lease should clearly outline tenant responsibilities regarding maintenance and repairs. Include in your lease, number 1, the tenant's responsibility for keeping the property clean, including the yard, and how they should report repair requests. Now, we always require requests to be in writing, whether through our portal or an email, and we always follow up with something in writing. If you end up in court, you want to be able to present a trail of what happened that led up to the dispute. Now, according to the law, it is the landlord's responsibility for repairs for repairs and regular maintenance to be the landlord's responsibility. In addition, most judges will tell you that if you supplied it, you fix it, and this includes appliances. So, for example, if you included a washer and dryer, you may need to repair or replace it. So don't install anything in your rental if you're unwilling to maintain it. Next, how do you handle repair requests? Well, you may need to outline procedures that include the time frame to respond, the address or how you plan to address it, how emergency repairs are handled, who needs to be present or not. Well, what if the damages were caused by the tenant? How do you handle that? And finally, what if the tenant does not adhere to their responsibilities? What do you do then? Well, a clear maintenance clause helps prevent disputes over repair responsibilities. It will also ensure that your property remains in good condition. My fourth clause has to do with the use of the property and its restrictions. Now, the world went crazy with Airbnbs, and a lot of renters were renting homes trying to turn them into short-term rentals, while you, the landlord, were responsible for quick repairs between guests, and most landlords didn't even realize this was happening. Well, now there's nothing wrong with a master lease if you allow it and you know what you're getting into. Well, in many cases, tenants default on the rent if they're not able to keep the home lease through Airbnb. Now, we only permit homes to be used as residential living space. So in our lease, we specify what the property can and cannot be used for. And you can bet we prohibit short-term and subleases. We include a clause that clearly states that the property is used for only residential purposes. And we prohibit all illegal activities. Believe it or not, you do have to specify that. No subletting without permission, and no business use such as inventory storage and distribution. We also include our rules about pets, pet sitting, smoking, partying, and noise. We also indicate that the garage must be used as a garage and must be able to park the cars, not to be used as a storage unit. Carports, decks, porches cannot be used as storage, and all area of the basement must be accessible. And finally, we specify that no changes to the property can be made without our approval. And this includes paint, mirror changes, and anything structural. You would be surprised what tenants do. Well, setting clear property restrictions allows you to evict and take legal action if necessary. And finally, our fifth clause includes clear renewal and termination clauses. In today's world, tenants think nothing about signing up for a lease and then breaking it. They think they can just give you 30 days to 60 days notice and they're out. Well, first, your renewal clause should state that when the lease renews and what the rent increase will be. State law generally says you have to give the tenant 60 days notice of any changes in terms, which would include a rent increase. We specify that our lease automatically renews on their anniversary date unless the tenant gives us 60 days notice to terminate. And we also specify a rent increase in this notice. For terminations, we specify a 60-day notice at the anniversary date. But if the tenant wants to get out of the lease at any other time, we provide a buyout option. In our buyout, we require the tenant to give us at least 30 days notice because generally a buyout is for a sudden reason like a job transfer or maybe a divorce. Or they are required to pay 2 months' rent as a buyout fee, plus pay the normal rent until they move out. Now, we require buyout payments to be made within 7 days of notice, and if they don't pay, then we assume they canceled the buyout. We also provide provisions for when we want to terminate the lease. Now, there are times when the property may become damaged, such as roof collapse from a branch or mold or any number of things. And you must provide provisions for making the tenant move under these conditions. Without clearly defined renewal and termination clauses, both the tenant and landlords only open themselves up to financial losses, evictions, and lawsuits. Well, to us, these were the 5 most important clauses to include in your lease. They create clear, fair, and legally sound lease agreements. It protects your property, clarifies expectations, and ensures a smooth rental experience for both you and your tenants. At Atlanta Area Property, we understand the importance of a well-crafted lease, and we have developed a strong one with over 15 years of experience, plus a thorough legal review. Watching out for our owners is our #1 goal. If you need any assistance, please don't hesitate to give us a call. We'd be delighted to see if we could assist you.